Kenyan legislators are set to review amendments to the Copyright Act, which will remove any obligation by internet service providers to take down content which infringes on the rights of copyright holders. The changes are contained in the Copyright Amendment Bill of 2021. In October, the bill proposed to remove legal mechanisms by which IP rights holders could issue formal notices to ISPs in order to take down a pirated material. Now, my colleague Ramanyang spoke to Liz Lenjo, who is a Kenyan advocate of the High Court specializing in IP law. And Ramanyang started the conversation by asking Liz Lenjo what problem this bill was trying to remedy.
For us as legal practitioners, we've actually been asking ourselves that question, basically because the bill had been trying to repeal the provisions on internet service providers, takedown notice provisions. So it was basically trying to get rid of that. And it's a very big provision in our Copyright Act as far as exploitation of copyright works in the digital space is concerned. What it has also introduced now is a prescribed revenue share for digital sales of music and other works. The people in the entertainment industry seem to have taken it well. They're happy with that. So I guess if the industry is happy to have that, then that's okay. But for us, the takedown notice was a big deal.
But these provisions, especially the ones to do with takedown notices, as I understand it, those are fairly recent because they came into the Copyright Act back in 2019, didn't they?
Yes, they're fairly recent. The challenge has been that they were yet to be officially utilized or exercised because we were still working on regulations on how to engage the ISPs as well. So aside from just having the simple contracts, pop-up contracts that we have online, what more can legislation or regulation do to assist with that?
Let's take a simple example. Let's say someone takes a clip of a match, say on SuperSport, of something in the English Premier League. By definition, they're not the copyright holder. They upload that then on Facebook and on Twitter. SuperSport sees that and then issues a takedown notice to the ISP that they believe this person was working on. What are the current problems in enforcing those takedown notices?
It depends on the different jurisdictions. With some platforms that we have seen, the time it takes for some of these issues to be resolved might even take up to 42 days. So you can imagine, and it's sort of an automated response system because I guess of the numbers. And by the time they get an individual, either in the legal department, to review this claim, it might take about 42 days. So that's one of the challenges that we are seeing. And as far as, for in the content business, as long as your content is down or it's been flagged for infringement, you're losing time and money, right? You're losing opportunities. So 40 days is a little bit too long for disputes to be resolved, to be reviewed. So that's one. I think secondly, for us now in Kenya, we are still to find more effective ways to have that effected with our various ISPs. So you find that unless, you almost threaten with some litigious action, that you get some audience with some of these ISPs.
ISPs are simply not taking action because from their perspective, there's no legal downside. There's no financial downside, for lack of a better word, to them getting a takedown notice. If they get it, they'll say, yeah, but, it's not our problem. What are you going to do?
Yeah, so you see, if Section 35 was to be removed, that would be the greatest issue. Right now, because we do not have jurisprudence in Kenyan courts against ISPs, then you find that ISPs may seem to be comfortable. The Kenyan population specifically is not litigious as we would hope them to be, or not as litigious as, say, the US, for example.
Let's say, for argument's sake, the bill goes through Parliament, President assents to it, it becomes law. What implications does that then have for Kenya with respect to the international trade treaties that we've signed up to? AGOA, for example, the economic partnership agreements with the EU. Will we be in violation of those trade agreements if this bill becomes law?
Let's put it this way. We'd be very unattractive for business if we were to pass such provisions. Because remember, we are working in an ecosystem, in a global ecosystem. And, you're looking at the international treaties and conventions. It's about having a level playing field across board, right? So the minute we repeal such important provisions, we are automatically saying, you know what, we are no longer open for business. We never want to be in such a situation.